Hello everyone, hope you all are fine. Welcome to our channel Scientellectual. In this video, we are covering Chapter 5 under Indian Patents Act 1970. Chapter 5 deals with opposition proceedings to grant of patents. More particularly, in this video, we are covering Section 25 under Chapter 5. Section 25 deals with opposition to the patent. Section 25 says about pre-grant opposition as well as post-grant opposition. First, we will discuss about pre-grant opposition. Section 25, subsection 1. When patent application is published but not granted, any person in writing to the controller may raise opposition against grant of the patent. That is, any patent application is published but not yet granted. In that period, any person, if he thinks that pre-grant opposition may be raised, then he can file pre-grant opposition in writing manner to the controller on the following grounds. Let's discuss the grounds. A. Applicant for the patent or the person under or through whom he claims wrongfully obtained the invention or part from him or person under or through whom he claims. That is, if any person finds that a patent application has been filed where applicant has wrongfully obtained the invention or part of the invention from him, in that case, he can raise pre-grant opposition against that patent application. B. Invention claimed has been published before the priority date of the claim. There are two subclauses. 1. Patent application made in India on or after 1st January 1912, or number 2, in India or elsewhere in any other document. That is, in patent document or as well as non-patent document. If the patent application under consideration has the subject matter which has already been published before the priority date of that patent application, in that case, pre-grant opposition may be raised, but before the grant of that patent. There is some exception that will be discussed when we will discuss Section 29. Let's discuss other grounds as well. When patent application claimed published on or after priority date of applicant's claim and filed in pursuance of an application for a patent in India, being a claim of which the priority date is earlier than that of the applicant's claim, that is, in case of pending application. Maybe it has been published on or after the priority date of applicant's claim, but actually it has priority date earlier than the applicant's claim. Then pre-grant opposition may be raised against that patent application. Next ground, D. Invention claimed was publicly known or publicly used in India before the priority date of the claim. That is, in case of any patent application has claimed a subject matter which is already publicly known or publicly used in India, then pre-grant opposition may be raised against that patent application. Next ground, E. The invention claimed is obvious and no inventive steps having regard to the matter published as mentioned in clause B, or having regard to what was used in India before the priority date of the applicant's claim. That is, any patent application which is obvious and has no inventive steps, then also pre-grant opposition may be raised against that patent application. Ground F. The subject matter is not patentable under this Act. That is, if it falls under Section 3 or Section 4, then also pre-grant opposition may be raised. Ground G. The complete specification does not sufficiently or clearly describe the invention or the method by which it is to be performed. In that case also, pre-grant opposition may be raised against any patent application, but it is to be done before grant of the patent. Next ground, age. The applicant fails to disclose to the controller the information required by Section 8 or false information to his knowledge. In that case, pregrant opposition may be raised. We know that under Section 8, statement and undertaking needs to be furnished regarding all the necessary information of parallel pending applications. If applicant fails to do so, then pre-grant opposition may be raised against that patent application. Next ground, I. In case of convention application, the application is not made within 12 months from the date of the first application for protection for the invention made in convention country by the applicant or a person from whom he derives title. That is, in case of convention application, within 12 months from the date of first application, convention application has to be filed. If the applicant fails to do so, then pre-grant opposition may be raised against that convention application. Next round, J. Complete specification does not disclose or wrongly mentions the source or geographical origin of the biological material used for the invention. Then also, pre-grant opposition may be raised against that patent application. Ground K. The invention claimed is anticipated having regard to the knowledge, oral or otherwise, available within any local or indigenous community in India or elsewhere. Ground K also deals with anticipation, but in this case, it is known, that is, the subject matter of the patent application is known orally or in any other way within local or indigenous community in India or anywhere in the world. Then also pre-grant opposition may be raised against that patent application. There are no other grounds based on which pre-grant opposition may be filed. The learned controller will call for hearing if the person is interested and dispose the representation in a manner and within a period as may be prescribed. Now let's have a look on the relevant rules related to pre-grant opposition. Rule 55. Any person may file to the controller in Form 7A against the grant of patent at appropriate office. That is, pre-grant opposition is to be filed through Form 7A. The time is any time after publication but before grant of the patent. And grounds are that has already been discussed, only based on that grounds. If any pre-grant opposition is received after the grant of the patent, then controller shall return the pre-grant opposition to the opponent and shall intimate the opponent about the fact of grant of the patent. If that opponent is still interested to file opposition, he may file post-grant opposition because now that patent application has already been granted. Rule 55 again says, a patent is not granted before the expiry of 6 months from the date of publication. A person may file pre-grant opposition within the assured period of that 6 months from the date of publication. That is, the safe period is 6 months from publication before grant of the patent. Next, Rule 55 also says that the controller shall consider the representation only after request for examination for that application has been filed. Next, Rule 55 also says that on consideration of the representation, if the controller is of the opinion that pre-grant opposition has merit, an application shall be refused or amended, a notice will be served to the applicant. The representation shall include statement and evidence in support of such representation and request for hearing, if hearing is desired. The date of grant of patent is the date on which controller orders the grant of patent in the file. Any pre-grant opposition, if available on record, is considered by the controller along with the report of the examiner. In Rule 55, it is also said that the applicant shall, if he desires, reply to the notice to the controller by filing his statement and evidence in support of his application within 3 months from the date of the notice, and a copy to the opponent to be served. On consideration of statement and evidence filed by the applicant, the representation including statement and evidence filed by the opponent, submission made by the parties, after hearing the parties, if they request to do so, the controller may either reject or require the complete specification or documents to be amended, or maybe refuse the grant of patent of the application by passing a speaking order under section 15. And ordinarily that is done within 1 month from the completion of above proceedings. Now let's discuss post-grant opposition. It comes under section 25 subsection 2. At any time after the grant of the patent, but before expiry of period of 1 year from the date of publication of grant of patent, any person interested may give notice of opposition to the controller in prescribed manner on particular grounds. That is, if any patent application has been granted. After grant of that patent application, any interested person, if he thinks to raise objection or opposition against that patent application, then he may do so in prescribed manner on following grounds. Now, following grounds are the grounds that are as same as in case of pre-grant opposition. Only the difference is pre-grant opposition is to be raised before grant of patent and post-grant opposition is to be raised after grant of patent application. And also, pre-grant opposition may be raised by any person and post-grant opposition may be raised by any person interested. Now, what is the difference between person or person interested is clearly mentioned under section 2(1)(s) and section 2(1)(t). The relevant rules regarding post-grant opposition are Rule 55A to 59. These rules says any person interested may raise post-grant opposition through Form 7 and the time period is any time after the grant but within 1 year from the date of publication of the grant. Rule 57 says the opponent shall along with the notice of opposition send a written statement setting out the nature of opponent's interest, the fact upon which he bases his case and relief which he seeks, and evidence, if any. The post-grant opposition can be filed on any of the grounds as mentioned in section 25 subsection 2, but no other grounds. That is also valid in case of pre-grant opposition. After receipt of notice of opposition, the controller shall notify the patentee about the fact and receipt of such notice without any delay. The copy of statement and evidence, if any, shall also be delivered to the patentee by the opponent. Rule 58 says, if the patentee desires to contest the opposition, he may file a reply statement setting out fully the grounds upon which opposition is contested and also the evidence, if there is any, in support of his case within a period of 2 months from the date of receipt of the copy of opponent's written statement and evidence. He will deliver a copy to the opponent. If patentee does not desire to contest or does not file any reply or evidence within 2 months, then that patent application will be abandoned. And controller shall issue order of revocation of patent and fact of revocation will be entered in the register in the patent office. Rule 59 says, after receipt of reply from the patentee, the opponent may file his evidence in reply within 1 month from the date of delivery to him of a copy of the patentee's reply statement and evidence. The evidence in reply by the opponent shall be strictly confined to the matters in the patentee's evidence. The opponent shall also deliver a copy of his reply evidence to the patentee. Rule 60 says, no further evidence shall be delivered by any of the parties except with the leave or direction of controller. Rule 61 says, where a specification or other document in a language other than English is referred to in the notice of opposition or statement or evidence, an attested translation in English to be furnished along with such notice or statement or evidence. Rule 62 says, further evidence can be filed by any of the parties if the same is prayed before hearing is fixed by the controller, whereupon the controller shall dispose of the petition by either allowing or rejecting. Evidence shall be filed and affidavit as required under Rule 126, and exhibits shall be filed as required under Rule 127. Now let's come to subsection 3 under section 25. As discussed under subsection 2, the controller shall notify the patentee regarding the postgrant opposition raised. Next, he will constitute an opposition board consisting of officers as he may determine and refer the notice of opposition to that board. And then every opposition board constituted will conduct the examination. The relevant rules regarding constitution of opposition board is Rule 56 to 60. After receipt of notice of opposition, the opposition board is constituted by the controller, and all the documents filed under Rule 57 to 60 in connection with the opposition by the opponent as well as patentee will be considered. There are 3 members with one of them as chairman in the opposition board. The examiner who has dealt with the application for patent during the prosecution proceedings for grant of patent shall not be included as member of that board. The board shall now submit the report with reasons on each ground taken in the notice of opposition. After examining the notice along with all the statement or documents or evidence submitted by the parties, within 3 months from the date on which all such documents were forwarded to them, then a copy of recommendation of opposition board will be provided to the parties to the proceedings by the controller along with the hearing notice. Subsection 4 under section 25. On receipt of recommendation of opposition board and after giving the patentee and opponent an opportunity of being heard, that is, hearing has been done, then controller shall order either to maintain or to amend or to revoke the patent. Subsection 5. While passing an order as discussed under subsection 4 in respect of the ground mentioned in clause 2d or 2e, controller shall not take into account any personal document or secret trial or secret use. Subsection 6. In case the controller issues an order as under subsection 4, the patent shall be maintained subject to amendment of the specification or any other document. The patent shall stand amended accordingly. That is, if any patent has been amended as per controller's recommendation, then that amended subject matter or application will be considered thereafter. Let's come to hearing procedure. The rule is Rule 62. On completion of presentation of evidence and after receiving recommendation of opposition board, the controller shall fix a date and time for hearing and inform the parties at least 10 days before. On receipt of notice of hearing, if either party desires to be heard, he will give notice to the controller along with the fee. The controller may require the members of opposition board to be present in the hearing. If either party intends to rely on any publication at the hearing that is not yet furnished any statement or evidence, he shall give the other party and the controller a notice of his intention together with details of such publication, and such notice shall be given at least 5 days before the date of hearing. The controller may refuse to hear any party which has not given any notice or not paid the prescribed fee. After hearing or not hearing, that is, if any party is absent during hearing procedure, then taking into consideration the recommendation of opposition board, the controller shall decide whether to revoke the patent or to amend it or to refuse it by issuing a speaking order accordingly. If amendment of specification or any other document is ordered by the controller, the patentee shall submit such amended document to the office within a reasonable time as directed by the controller. These are some important case laws that come under opposition. Neon Lab versus Troika Pharma Limited, or Novartis AG versus Natco Pharma Limited. Another case law is Hindustan Lever Limited versus Godrej Soaps. These are the relevant forms, Form 7 and Form 7A, and also hearing. The fee for hearing for Form 7 and for Form 7A is shown here. Thank you all the viewers for watching the video. Please give a like, share and subscribe the channel Scientellectual. We are aiming to provide you all the necessary information regarding the preparation of patent agent exam. We will discuss the sections, rules, forms and fees and also case laws related to Indian Patents Act 1970. Thank you again.